stupidity is repeating the same experiment and expecting different results. I urge you to pass House Bill 1173. Thank you.
Thank you for the testimony. Any questions, Dr. Wolf? Thank you, Doctor. We appreciate you being here today. Good morning.
Good morning. My name is Dr. David Redfern. I'm a practicing OBGYN in Springfield, Missouri, where I've been in practice for 25 years. I'm past chairman of the Missouri section of ACOG and the current secretary of the Missouri State Medical Association. I have much interaction with my physician colleagues, especially those in the field of OBGYN. I'm uniquely qualified to testify on the effects of the cost of medical malpractice insurance, also known as professional liability insurance. Because of my role as a practicing physician in a high-risk specialty. In 2004, after 15 years in practice, I was forced to discontinue obstetrics due to the high cost of medical malpractice insurance. Despite not having any lawsuits, I found that I had to pay $105,000 per year for a standard $3 million policy to deliver obstetrical care. To put that in a different perspective, Missouri hospitals, approximately 50% of births are covered by Medicaid. Medicaid pays physicians a global fee of about $1,000 to provide antepartum care, intrapartum care and delivery, and postpartum care. With a premium of $100,000, busy Missouri obstetricians deliver about 15 to 20 babies per month. On the top end of that, if I do 20 deliveries a month and get that $1,000 per delivery, it takes me 5 months to pay for the premium that I was charged in 2004. I have an office that has a nurse, a medical transcriptionist, a receptionist, an office manager, a lab technician. They all want to be paid, and they all want benefits like health insurance. Given the high cost of these premiums, in 2004 I just simply could not continue to practice obstetrics and gave that up for 3 years until the legislature passed tort reform and limited the effects of the crisis on malpractice premiums. The decision of the Missouri Supreme Court to allow unlimited non-economic damage will cause another crisis in Missouri. My colleagues are already making plans to adjust their practices if those premiums return to the early 2000 levels. 1 in 10 obstetricians in Missouri quit delivering babies during the last medical malpractice crisis, just as I had to stop for 3 years until common sense tort reform legislation was passed and signed into law. House Bill 1173 creates a statutory cause of action to replace common law action for damages related to the provision of health care by physicians. In simpler terms, it allows the setting of a reasonable cap for non-economic damages and will help keep liability premiums reasonable, as well as allowing physicians such as myself to continue to practice OBGYN. I urge this committee's support of the bill without further delay. With that, I'd be happy to answer any questions the committee members may have. Questions, Representative Hart?
See, Mr. Chairman.
Please.
Dr. Redfern?
Yes, ma'am.
Just to ask questions, I'm sympathetic to what your story. You were OBGYN?
I am currently in a valid way to get back into the obstetrics after a 3-year hiatus.
Okay. Is it true that based on your specialty, that some specialties you go into are higher risk than other specialties?
That is correct.
So the field of OBGYN, based on that specialty, the insurance companies basically increase your premiums just because you go into a certain type of practice?
Well, I'm not really qualified to testify on all the nuances of how insurance companies set premiums, but I do know that they base it on risk and also past history. The the issue with the unfettered, unlimited, non-economic damages is it's hard to predict that going forward, as in my case, where the premium was unrealistically set at $100,000 a year, despite my not having any previous lawsuits in veterans.
And that's my point. Wouldn't you be fair to say that the way that, I know you're not an insurance company, but the way they kind of give their analysis of your field and previous other doctors in your field, they use that to set your price for your insurance? Is that fair to say? And to me, that seems a little unfair. I don't know if you think that's a little unfair, but I think, you know, you, like you said, your record is clean versus someone else's, so you're basically paying for previous dealings in that area.
The same in health insurance.
Yeah, I
You know,
understand.
when I'm not ill, I help to pay for other people's premiums as well.
And also, you were talking about the tort reform in 2005. So right now we do have caps. Is that correct? Just
No,
what area?
Because of the ruling of the Supreme Court, which was a very narrow decision, the caps on non-economic damages have been overturned, and there is no limit.
That's just one area, right? Because other caps are still set. Is that correct? Like they set caps on other areas.
Yeah, there are other areas, but this is the area of our primary interest.
Thank you.
I'm curious if you've seen any impact since the court ruling in July of 2012 in your premiums. Have you been able to, we're about a year and a half now or so from that point, have you seen any impact of premiums since the 2012 decision?
Yeah, the market's beginning to get tighter. Premiums are starting to rise. In 2004, I was insured with a different company than I am right now. I worked for a large health system, and we're self-insured.
Thank you. Further questions? Seeing none. Thank you, Doctor. Before we go to the next witness, we're going to go ahead and call the roll. Call the roll. Here.
Here.
We have a quorum. All right, we're going to go back to the hearing on 1173. Good morning.
Good morning, Chairman, members of the committee. Thank you for having me here to speak with you today on House Bill 1173. I'm Jerry Blair. I'm a practicing ophthalmologist from Columbia and currently president of Missouri Society of Physicians and Surgeons. And again, my colleague and your previous testifiers here have, I think, clearly outlined some of the past history and some of the problems we're encountering, and really some of the problems we expect to encounter in the future. And some of the particularly difficult things we encounter here is paying on to the physicians we have under this environment and recruiting physicians. So we particularly find that, as was elucidated to the perfect storm of increasing patient population, the influx of new patients with the ACA, and the nature of our practice, at least in ophthalmology, having trained changed so that we have many turning older patients, just increase numbers significantly, requiring more manpower. And we're encountering ourselves problems in recruiting physicians to Missouri already, having looked over the last year, really not getting a lot of response from physicians when we try to recruit them. Issues with tort and malpractice being only one of those issues, obviously. I personally, fortunately, knock on wood, if you will, have had no direct experience with malpractice claims or cases, and that's fortunate. I think that has to do with the way we try to practice medicine, know our patients, build those relationships. But even without any prior claims or experience, unfortunately, insurance companies do look at the other actuaries, calculate the future, and just try to estimate their costs. So even before we may see cases, begin to build and claims rise, the malpractice premiums will certainly rise in advance of that. We're also seeing that in the way and physicians look to move their practice, as I was elucidated to friendlier environments, particularly some of our bordering states, make that available to them, such as in Kansas City, from Kansas City, Missouri, Kansas City, Kansas, for those looking to go part-time in their practice, such as for the practice part-time for family reasons, other reasons. It doesn't really lower one's malpractice insurance if one chooses to go part-time, which many of our female colleagues will do that during the periods of time of their raising families, having children, my own partner. It doesn't reduce their malpractice premiums when they're in that stage of their life. So I would appreciate your looking favorably on our position in support of moving forward with House Bill 1173 and reinstating non-economic tax so as to avoid another crisis that we experienced in 2005. Thank you for your time this morning.
Thank you, Doctor. Questions for this witness? Seeing none. Thank you very much.
Good morning. My name is Dana Fries. I'm testifying today on behalf of the Missouri Hospital Association and the Missouri Organization of Defense Lawyers. I am the Senior Vice President of Claims and General Counsel at Healthcare Services Group. We operate 2 insurance companies in the state of Missouri. Missouri Hospital Plan was formed in 1986 by Missouri hospitals to provide liability insurance coverage for themselves on the assessment plan under Chapter 383 of the revised statutes of Missouri. Missouri Hospital Plan insures 65 not-for-profit hospitals throughout the state of Missouri. The bulk of those hospitals are in outstate Missouri. As you well know, many of those hospitals are struggling financially for a variety of reasons. In addition, Missouri Hospital Plan operates Medical Liability Alliance, which is an insurance company that insures physicians in the state of Missouri. Collectively, we insure 65 hospitals and approximately 1,900 physicians in the state of Missouri. I am ultimately responsible for the claims asserted against those insureds in the state of Missouri. I'm here to provide a perspective from a liability insurance standpoint and what has impacted my business following the Watts decision on July 31, 2012. For 2005, until the Watts decision, we delivered on our promise to our insurers to reduce their liability insurance premiums in response to the 2005 tort reform bill. And in fact, we delivered on that promise and reduced our rates across the board approximately 30%. However, since the Watts decision, we have been unable financially to justify further rate reductions. And I anticipate that there will be rate increases in the future, especially when you look at some of the verdicts that have been delivered in the state of Missouri since the Watts decision. In 2013 alone, there were verdicts of $6.4 million, $4.3 million, and $10.8 million in the state of Missouri. Some of the plaintiff lawyers that you hear from today are lawyers involved in those cases. This bill has nothing to do with economic damages awarded by the juries in those cases. The lawyers that you'll hear from today and others in the plaintiff's bar are very, very skilled at maximizing the recovery of economic damages in those cases using the testimony of economists and life care planners. In particular, one of those cases alone had a $4 million economic jury damage award. This bill does not in any way affect that economic damage award. However, the awards of non-economic damages directly affects the premiums that we charge and the case reserves that I am required to establish under Missouri law as regulated by the Missouri Department of Insurance. In those cases that I mentioned, there were non-economic damage awards in one case of $2.16 million and $3.8 million in another case. That's in addition to the economic damages awarded, which are not impacted by House Bill 1173. As an insurance company and ultimately the director of the claim department, I am required to set a case reserve on each and every open claim. That case reserve must provide a reasonable estimate of the ultimate exposure that I believe my insured has for that claim, both for damages and also for defense costs. Combined, that is a liability on the insurance company's balance sheet. Not only must I estimate those liabilities accurately based upon my judgment, but we are required by Missouri law to have an actuarial firm every year evaluate our loss reserves and certify to the Missouri Department of Insurance, as well as to our board members, that those case reserves are accurate under Missouri law. The business of estimating loss reserves was more predictable, as you might imagine, when there was a non-economic damage cap. Now, in 2014, when I'm looking at these verdicts that came down last year for non-economic damages of $2.1 million and $3.8 million, for example, my job is much more difficult. But I must reserve accurately for those loss reserve exposures. Those case reserves are directly analyzed by the actuaries in setting what is the appropriate rate that we must charge as an insurance company. Our rates must accurately reflect our loss exposure. So logically, you can see, when I'm required to increase my case reserves to take into account the uncertainty of Missouri law with no cap, that is going to equate to, over time, an increase in rates. And that's going to adversely impact the bottom line of the not-for-profit hospitals that we insure that are otherwise struggling mightily, as you know, for a variety of economic reasons. So we face significant challenges. You will also see, because we no longer have a non-economic damage cap on bodily injury claims, you will see an increase in lawsuits. There have been several articles written about that in Missouri Lawyers Weekly and elsewhere in the past year. Plaintiff lawyers tell me consistently, well, now I'm willing to go to trial and try a case that otherwise I might settle because the sky's the limit on non-economic damage awards. I might get lucky and get a $2 million non-economic damage award or a $3.8 million non-economic damage award. But these cases are expensive to try. I sat down last week and calculated how much money did I spend for the last 15 jury trials that we tried in the state of Missouri. Most of those cases we won. The average cost to defend those cases, even successfully, was $207,000. If there's more lawsuits, the cost is going to increase, and as I mentioned previously, that affects the rates charged our insureds. In my opinion, as a lawyer, this legislature has the ability to amend Section 1.010 to amend the adoption of English common law, to take into account what we're dealing with in today's world with medical malpractice litigation. The Missouri Supreme Court in the Sanders v. Ahmed case in March 2012 upheld a cap on a statutory cause of action. So this bill is constitutional in that respect. As an insurer of rural hospitals and physicians, the higher insurance rates that will undoubtedly follow because of the Watts decision will put additional financial pressures on these hospitals. As many of you know, in outstate Missouri, if your local hospital is not the largest employer in your community, it's probably number 2 behind your school district. And if these hospitals cannot stay open, it will affect your communities across the board. Let there be no doubt about that. We are in competition with our sister states. Kansas, shortly after the Watts decision, upheld their $250,000 cap, and it makes Kansas much more attractive. If you're a physician and you practice in Kansas City, it's pretty easy to rationalize having your office in Overland Park, Kansas, compared to Lee Summit. The state of Kansas has done a lot of aggressive things, as you know, to make their state more attractive. And Kansas is not the only state that's upheld caps. Another sister state, Nebraska, has done the same, as well as other states across the country. Happy to entertain any questions. Thank you.
Questions?
Thank you. What's your name again, sir?
Dana Freese, F-R-E-S-E.
You were who again? I'm sorry.
I'm a Vice President of Claims and General Counsel for Healthcare Services Group in Jefferson City.
Okay, because you're a lawyer, so could you help me go through this bill for me?
Sure.
What are this bill is proposing to put what kind of caps on, and what's the amount of the cap they're trying to put through this bill?
Yes, it would be a cap on non-economic damages of $350,000 per claim. There would be no cap on economic damages, which would be, for example, past and future medical expenses, living expenses, lost wages, etc., loss of services. Those would not be capped.
In your opinion, your insurance, you kind of do the actuarial analysis of, like you said, you have your reserves that you base your insurance claims on. Do you ever reimburse in a group based on they have no claims or they haven't had any past malpractice suits?
And in fact, we do. Through Missouri Hospital Plan, we have been able to deliver dividends on a regular basis back to our insureds if we have an underwriting profit. And we have done that consistently over the years. For our physicians, if they have a loss ratio below a certain percentage, they are entitled to a partial credit or return of their premium. So we do deliver on our promise to return a portion of the premium to our insurers if their loss performance is good.
Can you kind of give me a breakdown of like what is the return? So I don't know, like the physician in a group,
Well, I mean,
will pay like for their.
The physicians have been getting in the range of 15 to 20% credit off their premium if their loss performance is satisfactory. And for the hospitals, it's been 20 to 30% some years.
But that's based. So is it based off of your analysis, or is it just the other factors also? Is it like say that you do it, you look at an individual's history, and then you have to make the final decision. Am I correct on whether you feel like based on factors that this reimbursement should be credited to this individual or group? Is it, you know?
Well, the way it works is this. I set an individual case reserve on each and every claim. And the component of that case reserve is what do I think the loss exposure would be if that case went to jury in terms of damages, and how much money do I think I'm going to spend to try that case, okay? I give each and every one of those case reserves to our actuarial firm, and they do a very sophisticated actuarial analysis. Then they will come back to us and say, your loss reserves are or are not within an appropriate range under Missouri law. Then at the end of a year, we look at our operating performance. And if across the board we've had an underwriting gain, and if a particular insured or hospital or physician had a satisfactory loss performance, then we return a portion of their premium. Because Missouri Hospital Plan is basically a not-for-profit entity. We are essentially an association of hospitals to provide liability insurance for them on a not-for-profit basis. We are not a commercial insurance company. We have been in this state since the 80s. We're going to be in this state for as long as we exist. We do not come and go like some commercial carriers do, depending upon how they perceive the state to be profitable or not. We are here to stay.
Thank you.
Thank you.
Further questions for Mr. Priest?
Seeing none, thank you very much for your testimony.
My pleasure. Thank you.
Mr. Chairman, members of the committee, thank you for allowing me to testify in support of this bill. My name is Bill Fish. I am the president of the Missouri Academy of Family Physicians. The MAFP, we represent approximately 1,500 family physicians in the state, as well as 500 students and residents with interest in family medicine. I practiced in Liberty, Missouri for 30 years, and during those 30 years, I've seen the climate of liability law in the state fluctuate a fair amount. In the first liability crisis during my career in the mid-'80s, I stopped doing obstetrics, I stopped delivering babies. With the next liability crisis in the mid-2000s, I had stopped doing vasectomies and other procedures within my own practice. And during some of these liability crises, at least in the mid-'80s, my own malpractice carrier of our group went bankrupt during that period of time. So it's not just a matter of massive profits being made by the insurers with this either. Our company went bankrupt and we dealt with that situation. I've watched colleagues during these different crises leave the state. I've had to recruit 26 physicians to our group. We have one of the larger primary care groups in the Kansas City area, and I've recruited 26 physicians during that time. We have 17 remaining. We've lost physicians when malpractice rates have gone up, when the risks have gone up, when they've seen a more attractive environment in other states. More importantly, we've seen our subspecialist colleagues leave the state. So it has been difficult, as one of the previous physicians mentioned, for me to get neurosurgical care for patients, for me to get dermatology for patients, for orthopedics especially. We've had a number of our orthopedists who moved to Kansas during previous liability crises, and we expect to see that again with the changes that occurred in 2012. In our own group, just as a vignette, I know that trial attorneys like to deal with individual cases or stories. I'll tell one with my own group. We had no suits in the 17-physician group prior to the 2012 verdict for many, many years. It was a good climate for us related to our premiums. But shortly after the Supreme Court threw out the non-economic damage limits in 2012, we had a suit filed against one of our members, a good friend of mine who I consider probably one of the best physicians I've ever worked with. In this particular case, it involved a blood thinner management. It wasn't managed by this physician, it was managed by a cardiologist. And when the cardiologist was sued, my partner was sued as well. The patient who sued him continued to come to see him as a patient. Said, "I love you, doc, but my attorney has said I can't just sue the cardiologist, I need to sue everybody involved with my care, because if they point fingers, I need to be prepared and sue them as well. But I love you, and will continue to come see you." But he was being sued. She said, "No hard feelings. The perception is that this doesn't hurt physicians in any way." For him, he continued to provide care for the patient. But what he had to look at is in Missouri, as of 2012, there's no limit on the risk that he's exposed to. As any of you would do in working in your careers for 25 or 30 years, as he had done, you accumulate some assets to provide for your family, provide for education, provide for retirement. He has to look at this as the potential that I could lose everything. I wasn't involved in the care of this. I would suspect that I would be found not negligent, but there's that risk. You're still dealing with individuals who make those decisions, and what involves with making that decision, you never can tell. So as a physician, you have that fear, that what if? And so he has to look at, I can settle this case for 5 figures. For $10,000, I can make it go away. I don't have to deal with the emotional toil, the stress it puts my family through, the time I miss from the office to prepare for depositions, the stress of an environment I'm not comfortable in, that I'm not prepared for, wasn't trained for. I can make it go away. The malpractice carriers who are going to spend $200,000 to defend this case can make it go away for $10,000. The attorneys can prey on that type of fear or that type of reasoning. They can file these cases and include as many people as they choose to and say, this doc, he's not going to want to take this risk when he can get out of it for a small amount of money. Maybe for a few cases they can bump fees up by taking lots of depositions, sending for records, raising fees, knowing that in future cases, doctors are going to want to settle. It's a hard thing not to do to settle. In this particular case, the physician chose not to settle, though the other physicians, the cardiologists involved who were actually doing the management of the blood thinner, they settled. What their reasoning was, whether it was for the same reasoning, hey, it's cheap to settle, I don't have to deal with this, they settled. But once they were gone, did the patient who said, I'm only suing you because we have to do it for everybody, they didn't drop the suit. They continued to sue, and he was the only one left in the suit. And he has to make a decision, do I want to fight this through? He talked with many of us, with his colleagues, and he and the insurance company chose to do what I think was the right thing. They fought the case, and there was very recently a verdict on his behalf, less than 30 minutes that the jury was out, and found for the defense and that there was no negligence in the case. But immediately after this, his malpractice costs doubled. So just from being involved in it, even though it was a quick jury verdict, his malpractice costs doubled from that in comparison to mine not having been sued. And the malpractice carrier said, well, we have lost money, we had to defend you, we have to regain those costs in some fashion. We'll either have to get those costs back generally against our whole group of physicians or individually. I think they do a combination of both. And I think we will see those costs rise as that occurs. The attorneys that you'll hear from later will talk about the worst of the worst cases, the child who's had a horrible injury, the veteran, the disabled. This physician I'm talking about is a veteran. This physician also has left primary care in Missouri after this case. And this is what we see for the future if this isn't changed. We've gone from some very bad liability environments to some reasonable liability environments, never an environment quite as good as the state adjacent to us, but now we have the worst liability environment we've ever had. We have no limits on non-economic damages. Economic damages, as Representative Gardner asked about, there's no limits there. When we talk about the plaintiff's attorneys will say, why would a case with somebody with just, maybe they lost a kidney, but they got another good kidney, they're suing, why would their damages be the same as somebody, a child who's had an injury, who will never be able to work? They're not the same. Economic damages are still unlimited. That child will have future earnings potential credited towards their award. They may still have a $10 million verdict. What we're saying is there needs to be a limit on the non-economic damages. Non-economic damages, not having a limit, or putting a limit on that, will not worsen the environment for our patients. Not having a limit does. It increases cost, it increases the number of suits, it increases physicians leaving the area, it prevents us from being able to bring on the very best. I think for your families and for Missourians, we want the best physicians available to be able to provide care for them. We already started at disadvantage as physicians in a malpractice case. We see people who've been injured. As a juror, you sympathize with somebody who's had a child who's been injured. We as physicians sympathize with them. We didn't go into family medicine to make a lot of money. We sympathize with those patients. We want them to be rewarded. I believe in the system. I think the juries, the majority of the time, will make the right decision. But when there is this liability lottery that we have in Missouri right now, we're concerned that too many nuisance cases like was filed against my partner will occur. It'll increase the cost. It'll chase doctors away. When they can go to the adjacent state and not have these rules, why would they not? So I encourage you at this point in time to get rid of the liability lottery. Patients will still be cared for. Patients will still receive damages when there's negligence. We should be focusing on giving damages where the damages are needed and to eliminate further negligence. It's not like having a big non-economic award is going to increase or improve the quality of care in Missouri. We want to prevent negligence from occurring. Every single case filed against a physician, whether it is found to be not, whether it's been found to be negligence or not, those are all reviewed by the State Board of Healing Arts. Our quality of care is addressed in every one of them, whether we have a verdict in our favor or against us. So the system is still weeding out where there are problems. Every malpractice insurance company who provides our insurance in the future is aware of every suit that we've had. Every employer, every hospital that we apply for privileges for is aware of our history, whether we were found non-negligent or negligent. The system does weed out those bad physicians. Are there bad physicians there? Yes. And it is addressed. We should be looking at preventing further negligence and awarding damages where damages are needed for providing care for those people. But having an unlimited non-economic damages really does set up a lottery system in Missouri, and physicians are afraid of that. I entertain any questions that you might have.
Questions for this witness? None. Thank you very much. many more witnesses are there in support of House Bill 1173? Okay, here's what we're going to do. We're going to take your testimony next. In terms of the order, if you traveled from out of town to be here today, I'd like you to come testify first. We do have session at 10 o'clock, so in the event that we're not able to finish all the testimony today, we will extend the hearing into next week. For those of you here in Jeff City, that will be easy, but I do want to make sure we get through everyone who's traveled to be here today. We're going to take witnesses on the proponent side until 9 o'clock, and then we are actually going to switch gears and take a couple of opponents, if there are some here, and I'm sure there are, and then we'll switch back to the proponents. So with that, please proceed.
Thank you, Mr. Chairman, members of the committee. My name is Dr. John Hagan. I'm a practicing pediatric anesthesiologist in the St. Louis area, Vice President of the St. Louis Society of Anesthesiologists. I'd like to testify again in support of House Bill 1173 on behalf of the Missouri Society of Anesthesiologists. In light of some time constraints, I'll try to be very brief. I grew up in the state of Missouri. I've been a lifelong resident. I received my undergraduate education at Truman State University, attended St. Louis University to receive my medical degree and to complete my anesthesiology training. I also recently finished my pediatric fellowship over at St. Louis Children's Hospital. I'm very proud of all that education. I'm impressed with the collective talent that we have in the state, and I'm happy to tell you that my wife and I decided that we would like to stay here for the duration of my career. I've been fortunate to stay in my hometown and to be in practice for 2 years. Unfortunately, most of the friends and colleagues that I went through training with did decide to go to other places. Certainly not, excuse me, not all of their decisions were based solely on tort reform, but in light of the Supreme Court's recent decision, Missouri has been made a less hospitable environment, as many people have testified to today. Certainly as physicians, we don't want to see patients ever hurt, and when they are, we don't want to see them struggle or not receive compensation for their injuries. However, I'm in the firm belief that the economic damage system that's in place can adequately compensate those people in the event of their injuries. I chose to go to medical school for the reason that I want to help take care of people in every instance possible. But I also want to spend my time doing that, working in the operating room, not going to the courtroom, hopefully ever. I chose to go to medical school, not law school. I want to spend my time taking care of patients. I urge the committee to consider this bill and hopefully pass it so that we can hopefully retain the physicians that are here and aid in our recruitment of the best physicians possible to increase and maintain the system that we have in this state and make it safer for people by having good physicians here. Thank you very much.
Thank you very much for the testimony. Questions for this witness? Seeing none, thank you very much. Next witness in support that isn't in Jeff City on a regular basis. All right, seeing none of those, we'll switch over and take a couple of. We'll take Mr. McCarty, and then we'll switch to a couple of opponents.
Mr. Chairman, members of the committee, I'll be very brief. Ray McCarty, President of Associated Industries in Missouri. We were shocked, as everyone else was, when the Watts decision came down. We felt like it was not the right decision. Certainly, we as employers across the state pay the price for increased medical costs and cost of increased medical insurance through our insurance. So we try to make sure our employees are covered, and this makes it more difficult as those costs increase. And we're happy to support this legislation.
Questions for Mr. McCarty? Seeing none, thank you, sir. We're going to switch gears now to some opponents of House Bill 1173. Good morning.
Good morning, Mr. Chairman, members of the committee. At the outset, I probably need to give some apology to Representative Cox. Unfortunately, he suffered through a lot of my testimony in the Judiciary Committees over the years, so he's probably heard a lot of this before, and I'll try to add a few extra new ones for you, Representative, if I can. My name is Ken Volstek, and I've been practicing law since 1980. I'm a graduate of Washington University School of Law. I have taught in the Medical Humanities Department at Washington University School of Medicine. I also am an adjunct professor of law at Washington University School of Law, where I teach a course called Protecting Patients, Physicians, and Attorneys as Advocates, teaching law students how to represent people who have life-threatening denials of health care from their insurance companies and how to work with physicians together on a pro bono basis to enforce those physicians' decisions to save their patients' lives. I also have been a commissioner of patient safety in the state of Missouri. In 2003 and 2004, I served on that commission, made up mostly of members of the insurance industry, regulatory bodies, as well as defense lawyers, and we came up with multiple suggestions for mostly rural hospitals on how they could avoid what are now known as never events, such as wrong site surgeries, things like that. But I'm appearing here today before you as the current president-elect of the Missouri Association of Trial Attorneys. So I'd like to give just a kind of a brief background to some very good questions from members of the committee today about what this bill does or what it doesn't do. But I'd like to kind of summarize for you briefly, if I might, where we're coming from, how do we get here today on this particular bill. Back in 1986 was the first time the state of Missouri passed caps on medical malpractice, and they said it was $350,000 for non-economic damages in all cases involving medical negligence. But there was also a cost of living adjustment, or COLA, we use in a shorthand term, that allows that cap to rise along with the cost of living, so that in effect the cap wouldn't be reduced each year because of the less buying power of the American dollar. That was upheld in '92, and then we had full reform beginning in 2003, 2004, and finally passed in 2005. I've been testifying in the legislature since 2003 on these issues. The cap that was eventually put on in 2005 involved $350,000, what we call a hard cap. That is no cost of living adjustment. So if you look at, so they went back to the cap of 1986, the original cap, and ignored the fact that cap had gone up to $570-some thousand by 2005, put it back at $350,000, which in today's dollars is about $185,000. What it would be back when we originally passed the cap. So the cap not only was reinstituted, but in a much more draconian and in a very, very real way, very small amount of money compared to what even in 1986 was typical. But more importantly, we didn't just reinstitute a cap in 2005. This legislature passed a very comprehensive bill. One of the biggest part of that bill was an insistence, and indeed with the support also of members of my organization, that there were cases that were being filed that had not been adequately investigated and filed against physicians that perhaps should never have entered the system. And because of that, we instituted a very strict, probably the strictest affidavit of merit requirement in the United States. And let me explain briefly what that requires for those of us who choose to file these type of claims for injured patients. An affidavit of merit requires us to get a physician, find a physician who has practiced within the last 5 years in the same specialty or subspecialty of the defendant or potential defendant doctor. And that person must give us an opinion in writing after reviewing the medical records, the films, whatever it may be that involves a patient's care, an opinion based on a reasonable degree of medical certainty that the doctor was negligent or made a mistake below the standard of care. That's in writing, provided to the attorney, and then the attorney, he or she, must then go and file an affidavit with the court saying, I have a written opinion, here's who I have it from, here's the person's name, here's their qualifications. And if the defense thinks that person is bogus, doesn't know what they're talking about, it's just some shill, just sending out an opinion so that he can make some money, they have every right to take that doctor's deposition and question anything about that opinion prior to the time that we move forward with the lawsuit. If we do not file this affidavit of merit within 90 days of our lawsuit being filed, then it will be dismissed unless we can, for good cause shown, extend that out to 180 days. After 180 days, it shall be dismissed, and it will be. You don't have that affidavit of merit. Now, so what's happened? Well, we heard Dr. Fish talk. There's one doctor, apparently, that was sued and stayed in the suit that he wasn't good for it. The jury said in 30 minutes, he's not good for it. The affidavit of merit has not stopped all suits from going to trial, and it hasn't stopped all people from being sued that eventually win in front of a jury for whatever reasons. But what it has done is cut down drastically on the number of lawsuits that are being filed in the state of Missouri, and that's been reflected, as we've heard in previous testimony, in the numbers of cases being filed. I don't think that has anything to do with the cap. It has to do with the fact that this legislature, your predecessors in 2005, passed a bill that had this safety provision in it for not only the protection of doctors and hospitals, but also for the court system itself. And I think that's a big difference in where we are now and where we are back in 2005 in that crisis. The other thing I want to talk about, the difference, is that my friend Dana Fries, the Missouri Hospital Association, mentioned to you that, yes, the Sanders case upheld a statutory cap. Well, what he didn't go further and tell you was, those are medical malpractice cases involving wrongful death. So when a hospital or a doctor, a physician, a healthcare provider negligently causes the death of a patient in the state of Missouri, their damages are capped at $250,000. The damages of those making that claim. Now, that's not to say that case won't be challenged, but it just came out 2 years ago, and I don't think the Supreme Court is going to be changing their mind on that. So what does that mean? Are we in the same position we were in 2005, 2003, 2004? Well, what's happened here is there's half an apple. That apple's been cut in half, and the more serious cases, the ones involving death, have a cap on it. Do we think that's fair as trial attorneys? Well, we don't think it's fair, and we never will think it's fair. But it is the law of this state, and as a practical matter, when we look at the market right now involving medical malpractice insurance coverage and on how much it costs, if you look at it actuarially, that's a fact. There's a $350,000 hard cap, no COLA on wrongful death cases. Okay, so that when we look at the statistics from the Department of Insurance that show that ever since 2005, the profit of insurance companies, the amount of money that they spend on Missouri Hospital Association is an exception because they're not for profit. But most of these insurance companies are for profit. They're making 80 cents on the dollar every premium dollar paid. They pay out 20% in losses in terms of defense costs and what they pay to the injured victims. The other 80% goes right here. And that's why you won't see them up here testifying. All right? And the fact of the matter is there's a number of Republican senators who knew that and understood that and stood up to the Judiciary Committee last year and said, where is the insurance reform? And it hasn't come. And it's still not here today. Now, I'm not here to stand up with these doctors and say, you guys are getting screwed over by the insurance industry. Okay? I think they know well enough what they're paying in the premiums. But I suggest to this committee that we look at this, we look at it longitudinally and say, what have we done? Where have we come since 2005? Okay? We've halved the number of cases in terms of their severity. All right? In terms of the $350,000 cap. Those death cases, we can't get any more than that. Insurance companies know that. We also have a situation where we have the affidavit of merit. Okay? So we don't see people fleeing the state. The numbers of doctors have gone up steadily every year since 2004, which is the year before malpractice reform was passed. We've got admittedly over 1,000 doctors more today than we did before. Now, I'm all in favor of getting the best doctors we can here. We had a person testify on behalf of Washington University, and the Senate said, oh, we can't get doctors to come to Washington University. Well, I suggest to you, that's just not true. All right? I know a lot about Washington University, and the fact of the matter is Washington University and St. Louis University and those institutions, they pay for the malpractice premiums for their doctors. They didn't come out of their pocket. They're protected. It has nothing to do with whether or not they come to Washington. They're fighting to come to Washington. It's one of the best institutions in the country. So, can we try to race to the bottom and try to compete against Kansas or try to compete against Nebraska and bring in the doctors who can't get a job someplace else because they've got a malpractice history and they want to run to a state that has the lowest hard cap they can find? Well, if that's the kind of competition we want to bring to this state, then we will be here each and every time to oppose a statute like this. And that's why we're here today.
To inquire. Just a legal question, and I haven't read it since last year, but the Supreme Court decision in July of a year ago, and I'm trying to distinguish that. When I read the decision, the first thing that struck me, because I was aware of what you testified, is the great change that was made, that's preserved in the law, that is in regard to the affidavit, the requirement of the affidavit. It was a significant change in the law when they. Why is that any different than a hard cap or a hard cap in regard to that reasoning of that court decision? Specifically, the reasoning was they struck it down is because the hard cap denied citizens, people who were injured, access to the courts. Isn't that a denial of the access to the court? If I can't come up with an affidavit, they throw me out of court. Isn't that a clear violation of access to the court, subject to being thrown out? So your basic principle, the basic argument of the most wonderful thing we have in law is going to be struck down. Don't you agree? I mean, is there any logical difference between a hard cap and something which clearly has to do with access to courts, an affidavit? It's like a permit. It's like me buying a ticket to a movie theater. Without that, they don't let me in the theater.
You know, I think there's a very clear difference.
What's the
I
difference?
think you're familiar with it because you're an attorney. It's called the
Well,
law.
unfortunately, I mean,
The law of summary judgment, the law of directed verdict, the law of the motion to dismiss, the law of the declaratory judgment. All those are factors that are done by the court prior to the case being heard by
yeah,
the
but
jury.
this is a creature of state statute. This is not a procedure. This is not different. This is different than any of the laws. If I file a lawsuit on a personal injury from a car accident, I don't have to file an affidavit. They're denying medical malpractice victims access to the courts.
I think it's just a procedural rule that just like any other one.
No, it's a procedural. It has procedural aspects, but it's an enactment of the legislature. It's a denial of the access of the courts, just like what the ruling in July of a year ago was. Isn't it identical?
I don't think it is, but and we've had this discussion before.
Well, I never had it with you, but at any rate, I just don't understand the difference. Well, how about the other thing? The decision, as you described, is the cap on wrongful death, right? $350,000. Is that what you testified to?
That's what it is. Yes.
Okay. Isn't that likewise a denial of access to the courts, just like the decision that we're discussing here today, subject to being reversed by the Supreme Court when they get the consistency of decisions? Isn't it? It's not only similar; it's identical, except one's dead and one's not. What's Mr. Who's have to say?
What do you say? Give me a little cheat sheet.
As I say, when I try a case, I have counsel sometimes pass me a note. Helpful sometimes.
Well, I think the difference, I guess, first of all, that decision talked about that was the wrongful death statute is a creature of statute. Okay, wrongful death act is a creature of statute, and so the court reasoned that because it was created by the legislature, it can be, amended by the legislature. That was the basis of the Sanders case, and then of course that was the same reasoning that they brought over into the Watts case, which is not about access to the court, but it's really about the right to trial by jury, and that you're at the end of the case after you've gone through.
You get a trial by jury if you don't get your affidavit filed?
No, you don't. Okay, but you can appeal that. If you think your affidavit.
If you don't have an affidavit, you can appeal it successfully.
No, it's struck down. You mean if you don't obtain one?
You can appeal it, but you're going to have to win to the Supreme Court and have it strike down the requirement of the affidavit, right?
Well, yes, but of course, if you have an affidavit, if you can't get an affidavit of merit, then there's no reason to bring a case. If no doctor is going to say anywhere in the United States there's any negligence here, it has no business being in the courts.
So you agree with it, even though it's clearly denial of access to courts, but you support that one, but the Watts decision, you support the other.
I just think it's a procedural mechanism, just like declaratory judgment and summary judgment, that allows cases without merit not to proceed to a jury.
It's a procedural that the legislature imposed in clear violation under the Watts theory of their decision.
Well, so far I haven't seen anybody challenge it on that ground, and I haven't.
I'm sure they will.
Really?
I mean, whether they'll be successful or not, but they should be if the court was consistent, because it's a ticket to get to a malpractice suit after the first few days of the lawsuit. You've got to have one. Thank you.
Let me back up and ask a more general question, kind of similar to Representative Cox's. That is, do you think that the approach in this bill is constitutional? So without distinguishing Watts and the affidavit, do you think this approach is constitutional?
You know, we've had a lot of discussion about that, as you might imagine. And you know, I obviously not a member of the Supreme Court. I have to practice in front of the Supreme Court. And I'm extremely reluctant to give advisory opinions to the Supreme Court, as you might imagine. So, especially in front of the legislature. I don't know the answer to that question. You know, I know that there's some pretty heavy, legal minds. You know, Harvey Kettlebond's been involved in this. He knows from the other side who believe it is constitutional. Okay. I personally do not believe that. Now, whether or not the court will find that way, I do not know.
What I struggle with on this is that, and I may have been of mind at one point that, the Watts decision clearly, I think, pointed to a constitutional problem. Typically, the solution to a constitutional problem would be to fix the Constitution, if you believe it was a problem. But what I wrestle with here is if you take the position that this approach is not constitutional, bring into question a number of other instances where the legislature has eliminated what would have been common law causes of action.
Such as?
Workers' comp.
And that is the one that it's always talked about, because of the social contract that took place between, in society saying we are going to trade off the fact that you have to show negligence against an employer, that you'll still get compensation.
And it would seem to me if workers' comp is constitutional, then that is an acknowledgement that the legislature has the ability to eliminate a common law cause of action and replace it with something.
Well, that's the only thing that I can think of, okay, where there appears to be some inconsistency, all right? And I do believe that the rationale, at least among the legal scholars that have written about the history of workers' compensation in our country, is that it was a joint social contract between the employees and employers in this country, that we decided that this would be fair to everyone involved. And because there is no need to show fault anymore, the fault is no longer part of the system. And that huge trade-off in the traditional liability system, i.e. going from a fault to a no-fault system, right, where you didn't have to prove that, but it did ensure that workers who were on the job, were doing what they're supposed to be doing, got some compensation. I think that was the rationale, as I read the legal scholars, when I read the history of workers' comp in our country. That's what supported that type of decision.
And on a macro level, looking at the policy broadly, I think I would agree. But if you're an injured worker and you believe that there was negligence on behalf of the employer, why wouldn't you have the same argument present in Watts to take your case to civil court outside the work comp system?
Well, I think the answer to that is the social contract idea. That's the answer to that argument.
The plaintiff in that instance wasn't a part of that social contract. The plaintiff has the same level of injuries that they did, regardless of whether the legislature back many years ago entered into that social contract or not. I'm just trying to figure out if you can have a system of compensation that the legislature can create that differs from common law, which we clearly have with work comp. Why can't the legislature do this, or why couldn't the legislature do this?
And I think that issue was briefed and argued before our Supreme Court, and has been argued in other cap cases. And I think the answer is given is the social contract. And all I can say is that, would it be better for a worker if an employer was grossly negligent and that they should be able to bring some type of action against them? Yeah, it would be better for them. I'm not saying that the law couldn't be better, but it's the trade-off too is have some certainty in the workplace and have business being able to operate and make a profit and do what they need to do.
But it would certainly be a weird situation, similar to what we have with the discrepancy between medical negligence cases and wrongful death cases. It would be a strange scenario if the idea was to protect the right to trial by jury. If an administrative system decided by an ALJ didn't violate a right to a trial by jury, but a cap on non-economic damages did. I mean, that would seem to me to be a very inconsistent result. The goal is to protect the constitutional right to trial by jury. Okay, thank you for the testimony. Further questions? Seeing none, thank you.
Good morning. Thank you for having me here. My name is John Wall. I'm an attorney in St. Louis, and a lot of my practice is involved in medical negligence cases, very significant, as a matter of fact. I'd like to mention, as one of the other witnesses, I am a Missouri native, born and raised in St. Louis. Went to Washington University Law School. Also come from a medical family. My father was a physician for over 50 years. Have another cousin who, for many decades, was chairman of OBGYN at both Thomas Jefferson University and at Johns Hopkins University, very famous physician. So I have no particular antagonism about physicians whatsoever, any way, shape, or form. I will tell you, when I first started doing this type of practice, I mentioned to my father, so what do you think about me being in the business of suing doctors, hospitals? The exact word, and this is someone who was on faculty at both St. Louis University Med School and Washington University, that some of them need to be sued. Exact words. So let's talk a little bit, a few things I want to mention before I want to talk about what I was planning on mentioning. One of the physicians who testified here today said he'd never been sued and his premiums were astronomical. That's not true. He was the subject of a wrongful death case in Springfield. He knows who he is. I'm not going to call him out by name. But he was the subject of a wrongful death matter in Springfield, Missouri that was litigated in the circuit court for 3 years. That's according to CaseNet, which is the Missouri court system official site where you can look at cases. So that's number one I'd like to mention. Another physician came up and said he had been in practice for all of 2 years, and I congratulate him for his fine achievement. He said that some of his colleagues, though, who he trained with, left the state of Missouri possibly because of an inhospitable environment. The Watts case is only a year and a half old. There has been a handful of very large malpractice cases since the Watts case. The juries are not, by the way, informed